Hello viewers, welcome to our program on immigration and legal affairs. I am your immigration attorney Michael Fulwani, and once again we have with us attorney David Nachman. David, welcome.
Thank you so much. Namaste, Michael.
Namaste. Okay, in our last programs that we have been talking about profession by profession, what kind of people, nurses, physical therapists and others, what kind of temporary immigrant visas they can get, and the processing, the requirements and all that. And we want to continue that subject today with performing artists. And when I say performing artists, could be singers, musicians, drama groups, people that are coming for performances, people are coming for shooting of movies.
Actors, actresses,
actors,
acrobats.
Yes.
Yeah.
So those are the, widely speaking, those are the groups of people or individuals sometimes that want to come to US to do performances, individual situations
Directors.
also. We had a big singer or a big musician that wants to come alone and maybe just have a band here, but he just wants to do the singing. All kind of these people, everybody needs a visa, remember. Now, one thing before I tell David to speak about that, most of these types of visas, the process starts here in the United States. And I still see, after so many years, after we've been doing these TV programs, newspaper articles and all that, it's still unfortunately we see people once a while, a singer or artist or somebody going direct to the American consul to apply for the visa. Consul cannot issue the visa. The process is like this. The organization here, the sponsors here in the US will have to file a petition with the Immigration Service in the United States. And that petition includes a lot of information about the background, publicity materials, itinerary, contracts and many things. And they have to get union clearances in some of the cases. And when the Immigration Service approves it, then only the American consul can issue the visa. So this is very, very important. Process starts here. You better have a good law firm that knows what to do at all stages of this case, not simple and plain filling a form and mailing to immigration. And we have seen disasters happening when you go to some lawyer or somebody who doesn't know what to do, and time goes by. I had a case like that, a big singer, I would say, in Madison Square Garden many years ago. And that he went to a lawyer, the first case for him, he never did it. He filled a form and mailed to immigration. And he kept on calling them. About a week before the show, the sponsor spent about $500,000 at that time. He was so worried. Oh, he says that, oh, they have denied your petition because there are no union attached opinions. So then he came crying. It's a long story. I don't want to go more into details. I say, even now, sometimes they go to the consulate and they get denial or they get advice. Go and file a petition first. So that with that, I'm asking David to go into a little more details about explaining to you about O visas, when they need O visa. These are the basic two categories, P visas and O visas for most of the artists.
Right. Well, O's and P's are some of the options. Of course, there are also possibly H-1Bs that might be available, or we can look at other visa classifications, and obviously we want to present our clients with all of the options. But I think that one of the really important points here, Michael, is also to emphasize to our viewers that no organization or no person is too small to be able to get an O1 or to be able to get a P3 or to be able to
you are talking about both in terms of sponsors who say, I've never done that before, this is the first time, it's okay, it doesn't matter.
Right, well, there are many organizations, for example, that we represent, which are very, very significant organizations and probably household words in India and some of them in the United States, in Indian households.
Right.
But we also have sort of a separate group of people who want to come in and they're performing artists, maybe smaller types of artists.
Because those type of artists, small ones sometimes are small community group kind of organizations, like in Gujarat, they have a Navratra festival. So these are not top Shah Rukh Khan, Salman Khan, those kind of people. They are small singers, but well known pretty much.
Cultural activities.
So the culturally unique requirement.
Right, and that could be either an O1B, which is an O1B is a visa for an artist, we call them artist visas, or a P3 visa, and the P3 visa is for individuals who are coming to the United States to engage in culturally unique activities. The O1 visa is good for a 3-year initial grant with incremental 1-year extensions ad infinitum, and the P3 visa, like the P1, is good for 1-year extensions for about 12
No,
months.
but you see, generally what happens, David, generally what happens, they are coming for performance. The performance itinerary says that they are going to be here for 2 months to do 7 performances, Chicago, New York, and all that. In that case, that time period is limited to the duration that they will be performing in the US. So those type of programs are for that specific duration only, as per their itinerary. Then there could be other I have seen, like O1 coming here, who has got several events lined up in the next 2 or 3 years.
Right.
But they want to know exactly documentation, itinerary information, contracts, everything to satisfy the immigration service.
That's right. And actually, Michael, you're hitting on the very important elements of doing a visa of that nature. One is that you have a good, solid itinerary. 2 is that you have to get union clearance, so you have to write away to the unions.
Or advisory opinions, we call it.
Right, and what's difficult is to try to figure out what unions you have to write to, because sometimes you have individuals who are sort of hybrids where you're not sure whether they're music people or whether they're performing people. Sometimes they fall into both categories.
Exactly.
So you have to kind of figure out with the unions who's supposed to be issuing that advisory opinion or no objection letter.
It happens a lot with the experience, right? And we have been doing for so many years. And during that course of many years of experience, when we have a big film shooting company comes from India, 100 people do a film in the US, for example. Now we look at all the kind of people who is going to be doing what, who is considered as an actor, artist, who is a photographer, who is a choreographer, and who is the camera person. Accordingly, there are different unions. There's the actors union, there's the producers union, there's the directors union, there's the makeup artists and other union, and we know that. So we right away, once we have all the paperwork, we analyze the case.
That's right.
As to what unions, how many unions, and we send to different unions.
Exactly,
and
for any given case.
We know that we have to send what their fees are, how much time they are going to take, and by this time most of the organization know us. And they really sometimes compliment us that your firm is doing a wonderful job, everything is just perfect. Nevertheless, there is still situations where the union will not give an opinion because they say it doesn't come within our union. For example, it is a guy that is a trainer of an actor, which happens these days, all those 6-pack actors, they bring their trainers with them. So there we say it's okay, but when we go to immigration service, give them all the opinion letters, we explain to them that this trainer, there's no union for them, so you can take into consideration whatever information, and immigration is very nice. They accept that, it's okay. They understand this union cannot give because the membership of that union does not include that kind of person or occupation.
I think, Michael, we have to take a break, but when we come back, what we'll do is talk a little bit about how to get green cards for these folks, not just the non-immigrant visa like the O and the P, but then again, the next step is how do you cross them over to get the green card on the immigrant visa side?
Please, we'll do that, but don't keep all my big artists here in the US, otherwise Bollywood going to cry and
well, now they're doing crossover. So crossover artists between Hollywood and Bollywood. That seems to be very big now.
Okay. Stay tuned. We'll be back after the short break. Thank you. Welcome back. Just before the break, we were talking about non-immigrant and immigrant visas for artists, performers, singers, musicians, and everybody else. Couple of words I want to say before. David wanted to also explain about how they can get green cards, permanent resident status. But just wanted to give you a brief information that any of the promoters that are planning to bring groups, whether it's a drama, whether it's a performance, whether it's a musician, or where there is a film shooting, make sure that you start the process at least 3 months in advance. because there are various important steps to be taken. Step number 1, we need lots of documentation about the artists, about the performance information, about the auditoriums, about the contractors, about your sale of those shows to the local promoters and everything else. Once we have all the paperwork, we can only prepare a petition after that. And then we send the petition and all the information to various unions for their, you can say, a non-objection certificate or an advisory opinion. That takes also about a week, 10 days we need to prepare, about a week, 10 days unions need the information, and about 2 to 3 weeks immigration needs to approve it. And then you have to make appointments at the American consulates, and they are sometimes blocked up, and after 2, 3 weeks, 4 weeks you get the appointments. So because this is a disaster, otherwise what happens is, if it is poorly planned, the performers here, or sorry, the promoters here would start selling the tickets, advertising, promotions, TV advertisements.
Tremendous liability financially, yeah.
And if that doesn't happen, if the artists are unable to come in time, disaster.
No pressure for the immigration lawyers, right?
Well, it does. It does
Of
a lot.
course,
Believe
of
me,
course.
I had situations where we accepted a case, whether even less than 3 months, 2 months sometimes, that they say, sorry sir, but I've already planned the whole thing, I cannot change, and pushed hard. As we go with the time, blood pressure keeps going up. What will happen if they don't come in?
Right.
Thank God, I would say 99% of the time that we have always been successful bringing the group in the timely manner. So it's a very, very important piece of advice. And with that, I think David is waiting here to tell you that how to get permanent resident status. Anything else you want to add also? No?
Yeah, well, permanent resident status, I think, doesn't come for all individuals who are coming to the United States as performers. Or a lot of the performers, of course, go back, and that's exactly what the non-immigrant visa classification was created for. But what's interesting is that the O and the P visa classifications are what we call dual intent, which means that you can intend to stay and intend to leave at the same time. So you can definitely initiate a green card application if your ultimate intention is to stay here in the United States. So what are the classifications that you would be looking at? Well, number 1 might be the PERM application, if you can find an organization that's willing to sponsor. And a lot of times, if you have an artist or a performer, they probably are pretty well situated. They can be sponsored by their agents. They can be sponsored by the production houses. It just depends upon what the relationship is. Oftentimes, those relationships are tenuous and they're not employee-driven. And so often, maybe a relationship directly with the agent might be better. However, the one thing you always want to look at when you're going to start a case like that is to make sure you have the ability to pay. Ensure that whoever it is who's going to be sponsoring has the ability to ultimately pay the federally mandated prevailing wage. So that's the first part of the analysis. So PERM is one way to go through the labor certification process. Another way to go, which is one that's a little less well known, is through what's called Schedule A Group 2. Schedule A Group 2 is a pre-certified classification, and what you do is you have to prove that the individual has what's called exceptional ability. It does require a sponsor, but it's a pre-certified classification, so you don't have to go through the labor certification to prove that there are no able, willing, and qualified U.S. workers who can take the job. We've used the Schedule A Group 2 classification for many of our artists, and they seem to go through fairly rapidly. The other one is the pre-cert. Now, that's an EB2 classification, by the way, which means
also, right?
Right. Well, we'll get to EB1 in a second because that has its challenges also. But that's an EB2 classification. And again, as everyone is aware, because we recently announced the numbers, those are unavailable right now to India. So we have to wait until October before those numbers will be announced for the priority dates to be moving forward. So, but still, EB2, Schedule A Group 2, is a faster classification for individuals to be able to stay here. As Michael properly pointed out, in EB1 classification, those are for individuals who have extraordinary ability.
They don't need a labor certification.
And they don't need to have a sponsor. They can actually self-sponsor. So individuals with extraordinary ability, and I think all of our viewers know who those individuals might be.
But David, most of these things you said, it's applicable to almost every occupation, not just artists and all that.
That's
let
absolutely
me
right.
add some last point on this. Very, very few prominent actors, artists, singers, or musicians, very few will want to get a green card. First of all, they really don't have any intention. They are so well known in India. They make so much money in India. They have families in India, ties in India. They don't really want to get a green card. Also, it comes with a liability. Green card holder or a citizen has to pay income tax on the worldwide income.
That's exactly right.
And so with the kind of millions of dollars that they make back home, they're not going to pay the taxes in the US, just becoming a green card holder.
That's right.
And then headache of maintaining a green card is that every year, every few months, they have to come back and forth and establish. So
right, but here comes the plug for good chartered accountants. If you have a really good accountant, you may be able to reduce your tax liability.
Well, I leave that to the accountant.
Exactly, exactly.
Okay, let's move on.
Well, that's another occupation that we can talk about.
Let's talk about those occupations. This takes us to various other people in the same group of people: accountants, architects, engineers,
other professionals.
IT people, other professionals.
Right.
When you say professionals, means they at least have a bachelor's degree or a master's degree, and their job requires that kind of education and experience. Go ahead.
Yeah. Well, those individuals, I guess we can first look at the non-immigrant visa side. Generally speaking, as many of our viewers know, those individuals are going to be coming on H-1Bs. Obviously, you know that we ran out of H-1Bs this year on January 15th. So we have to wait now until April 1st of 2013 to be applying for October 1st, 2013 start dates for the H-1Bs. But generally speaking, those professionals are going to be falling into the H-1B visa classification. However, that's not the only one. There are others. Go ahead.
See, amongst all the options, I tell you, I like, if possible, not everybody would qualify, L1 intra-company transferees. I'll give you reasons, and then you explain what is L1 and how it will work.
Sure.
L1 visas do not require a labor attestation like a guarantee of a certain wage.
Right.
L1 doesn't have a quota that filled up, right? It's year-round, available at all times.
That's correct, yeah.
L1, you can convert L1 to a green card in most cases within a year or two. The person
if it's an L1A and not an L1B.
Managerial capacity. So if a person qualifies for both, let us say L1 or H1 or some other categories.
And in order to qualify for an L1, you have to have worked for 1 full year within the last 3 years for a qualifying organization abroad coming to the United States to perform services as a manager executive or as a specialized knowledge employee.
But the conversion to green card is only for managerial or executive.
That's correct, yes.
So this is not, as I said earlier, to start with, that not everybody comes in that capacity. Right. But I have seen people that they don't think of L1, they want to apply for H1. And you talk to them, they're working in a company and they are coming here in the branch office or affiliate company in the US.
That's right.
I say, it's your company, why don't they file an L1 petition? Good company, good here, good there. I mean, L1 requires a lot of documentation to prove that there's an intra-company relationship between the parent and the subsidiary or affiliate company.
Right, the qualifying organization.
And about the financials, about the number of employees. And a lot of time they fail because they are not able to prove that the job, that the work they are doing is to be managerial or executive. I mean, the person is only company, one clerk and nobody else.
That's right.
It becomes a big problem.
Well, interestingly, Michael, when I was in India a couple of weeks ago, I was talking, I was in Mumbai, and I spoke to a lot of people when I was there. It was an excellent opportunity to do a lot of networking. And a lot of people don't realize that if they have a business there and they're seeking to come to the United States, there's something called a new company L visa, where what they do is they can have their Indian organization buy a U.S. company or open a new U.S. company and then transfer into the United States using the new company L. And what it is it's a form of backdoor investor visa, because then the first question that I get is, well, how do I have to capitalize that company? And I always go back to them and I say, well, why are you asking me this? Because apparently in India, there's a requirement for capitalization, which is different than in the United States. And then in the U.S., you don't have to capitalize the company. You can show some transactions and you can put some money in, but it's not required, I think, to make it as financially wealthy as you have to in India. So
good information, but to the viewers, don't take that very easily also, or very easy, okay, so there's a company and you fill up a form and you're going to mail it to the immigration service. And see, these days we have seen that the immigration service is very closely scrutinizing L1s as well as EB1 cases. So you have to document it fully. with financial information, number of employees, job duties, a hierarchy chart, and many things. You still have to look for a good experienced lawyer who knows how to handle it. And if then RFE comes, RFE means Immigration Service wants more documents, more information, and then how that can be overcome by providing all the correct required information to the Immigration Service.
Right.
And also let me tell you about the new companies. I have seen, and David must have seen, a lot of cases where there are lawyers who will tell them no problem, put a business plan, everything done, file it, 1 year, get it. They will get 1 year. The new companies get only 1 year.
Right.
And the old
well, you have to go back and you have
3
to
years.
extend after
So
1 year.
1
Right.
year goes by, then apply for an extension.
Correct.
And a lot of cases, they are unable to show that what they said, what the plan they gave in the beginning is not here. There are no employees still, there is no money here,
Right.
no, even the guy is even not taking his salary, what he said, and that gets denied. So it's very important that if you are plan from day one, plan also for going forward after 1 year what's going to happen.
Right.
So you run your company in a way, realizing, understanding that after 1 year I have to apply for extension and I'll be able to furnish those documents to get, otherwise you have a problem, big problem.
Right.
You invested the money, open the company, after 1 year they don't extend, you go back to home and business is gone
Right.
too.
Well, many of the people who I spoke to, Michael, were in the textile industry, and they had very clear plans. They were already not just in India, but they were already doing trade with Europe and some of the Western European countries. But their idea was to open up an office in the United States and to start trading through that U.S. office. So the idea would be that if you start trading through that U.S. office, keep very close eye on the transactions that you're doing and document everything. And of course, you don't have to pull a salary from the U.S. corporation, but it's best if you do pull a salary, because what it does is it further justifies the bona fides of the business that you're doing through that U.S. corporation. Yeah.
Another one that comes all the time. I am married, I'm a medical doctor, my wife is a medical doctor, we have 2 small children, I can want to bring a nanny from India, how quickly I can bring, what are the requirements, nanny. Now when I told them, it may 10 years, it may take, it's very difficult to bring a nanny for